Now to a debate which has been gathering steam lately. Right now in Australia it's illegal to use offensive or insulting language in relation to someone's race, but that law has come into question in recent weeks.
The government is trying to bring together a number of anti-discrimination acts in the one bill, but opponents are saying it's the right time to scrap the so-called offend or insult test. So should this kind of racial vilification continue to be outlawed? To discuss, we are joined in the studio by the President of the Human Rights Commission, Gillian Triggs, and from Melbourne by Simon Breheny from the Institute of Public Affairs. Good morning to the both of you.
Good morning.
Good morning. Gillian, what is the justification for retaining the offend or insult test in relation to race, but not in relation to, say, gender, sexuality, ethnicity, or other, differences?
Mm-hmm. Well, in fact, the government in its exposure draft designed to create this debate that we're having at the moment did intend that that standard would apply across all of those other attributes, pregnancy, sexual orientation and so on. But there's undeniably been a public rejection of taking the law quite so far. And I think this is, again, the opportunity for the government to pull back a little. But at the same time, I think the government is very keen to keep the race vilification laws, which have been on the books now since 1995,
yes,
and have been applied by the courts at a very high level. In other words, they've applied in egregious, serious cases of deep racial hatred.
Just on that, because I think that's a position with which you essentially agree. What is the philosophical difference between the hurt caused by insult around one's race and, for example, the hurt caused by insult around one's sexuality? Certainly the hurt is the same, is it not?
It is.
Or similar?
It is. And we fully agree that the prohibition should apply to these other attributes. But at the same time, the government has to listen to the public voice.
Yep.
Your question's a fair one. What is the philosophical difference? And there probably isn't one. And the law has been there in relation to these other elements for many years in the States, in international standards and practice. But you have to take notice of public views, and it just seems that at the moment this is a bridge too far.
Sure. Sure.
Okay, Simon, do you believe these kinds of racial insults should continue to be outlawed?
Look, this is fundamentally a question about freedom of speech. Freedom of speech is our most fundamental and important human right, and it's a real shame that we have people in the debate talking about where it should be restricted and restrained. And the Australian Human Rights Commission, I'm sorry to say, has been heading the charge in terms of where freedom of speech should be restricted. I begin from this point because it's fundamental to the functioning of Australian democracy, and it's the basis of a whole range of other rights that we have.
Simon, but that freedom of speech, though, is not an unqualified freedom, of course. I mean, it's restricted in all sorts of ways, in defamation law, in laws against incitement to violence, in laws against misleading advertising, for example. There are all sorts of ways in which our freedom of speech is restricted. Why is it that this restriction is seen as such an imposition on our freedom, whereas the others aren't?
Look, I mean, there's debates around all of these issues. The point here, I suppose, to make is that offend and insult, making a law that makes it unlawful to offend and insult, just goes way too far. It's a clear restriction on freedom of speech that shouldn't exist in the law. There are far better ways of dealing with these issues, and taking someone to court every time they hurt your feelings seems to me to be not a very good way of dealing with this issue.